So Ghana ha ope lawyer kese baako a onimumbra ewa hasia lawyer Thaddeus Sory ene waba ababe schoolie Akyea with legal wisdom and the judicial career ebusua enye asem keto akra legal vacation ehon sensema Akyea ne go fedame omo ko ho omo file petition to chief justice enke en hote the likes of Kojo upon Kroma and so enano ada or the motion and as of filing application to high court say enka ye oppose the legal vacation trials na ekoso na ene Thaddeus Sory lawyer Thaddeus Sory aba edin sembi aba betuja or kase sa legal vacation no emum say lawyers no ye mo kwan mo ko vacation there bet chief justice e wo ho kwan bia say say or panel judges na so omotena cases so case a opese ekoso no chief justice betumi ayesa ade ntino na nkomo odi to dwa no odi vindicate chief justice Paul Bafoboni judges a o choose omo say omundi oral cases bia ekoso ntinene lawyer Thaddeus Sory ababe schoolie Akyea with legal wisdom and ne political na say ne judicial career right now no Akyea is nowhere to be found. Ebusua yenko tie ensema lawyer Thaddeus Sory ene oba no ababe lecture wa me yehu se embra no onimumbra na ya bepese be makona makwakotie ensema course ye ba ya de aka ebeto am so unsubscribe ya subscribe and like it, hit on the notification bell and so send any update be ever dropping on when so unsa every to me akem na san be Ghana has a open computer papa and a laptop papa now we use Abura Perosi computers and accessories ho and I'll be your laptop papa na we using the location and yira kwan o Kumasi Buokrum Estate Eli frɛ number na egu screen na na de ba kwa de wo me se okura low budget no obema high quality laptop a ehon embassy no yembo ryan se ba de de aka ebeto amaso
needed to go on vacation and everything. Whatever it is history, I can tell you that lawyers need that vacation. It's not just lawyers but judges. And I always say that, look, this is not to minimize or to show disrespect to other workers. But we all wake up early in the morning and we go to work. Some people have what we call closing time. You get into some offices by 4:30, people are gone, and 5 people are gone.
9 to 5.
Yes.
8 to 4, whatever.
The normal life of a judge and a lawyer is different. You have to wake up very early. You have to start preparing yourself to go to court. Amidst the traffic that everybody goes through and all of that, you have to be ready, however you do it, in the traffic and in whatever way, you have to get to court ready. So it means you don't have as much time as other people have. If they have to prepare their kids, you still have to do all of that. Say you take care of your family and all of that, you still have to do that. But the client expects you to get into the courtroom prepared. The judge is supposed to be prepared for you when you get into the courtroom. Right after court, which stops around 2 o'clock, even if you leave the courtroom early, you get into the office. You have so many clients waiting for you to speak to you. You have to speak to them because you need to get their side of the story. You have to reduce it into writing. You have to file it. And so by the time people are leaving their offices, you are still in the office. And you leave the office 9, 10, 11, 12. When I was young out, I didn't leave the office before 12. And so at a point in time during the year, you need that vacation. You need it to be able to serve not just your client, but to be able to be your best as an officer of the court to the court. That judge who leaves their chambers, if they leave it early at all, they have to be writing rulings for the following morning. They have to be studying dockets for the following morning. And so even if we agree that it was for the colonial judges, we still need that today. And
so it's not an issue that you can say it's no longer applicable.
It's very, very relevant. Very, and when people say this, they don't even understand that during the vacation, there's still a lot of work that lawyers do. There's a lot of written submissions that they are writing for their clients. You are writing several pages. You are reading several records that are very huge. You get into my office and you see records of 6, 7, 8 volumes. And I'm reading all of that in the vacation. So the only thing that is taken away, or the only thing that you get reprieve from during the vacation, is court attendance.
But you're still working.
Yes. So you can ask me, so why didn't you take your vacation in January? But I'm appearing before different courts at every point in time during the legal year. So how am I going to, organize my legal vacation such that all these courts before whom I'm supposed to appear, they allow me that space? You can't harmonize that. You're appearing with another lawyer doing a case for his client. How do you harmonize that? So it is the best and most workable situation that we have right now, and that is working perfectly. During the legal vacation, it doesn't mean we don't do any work. We still even work writing the client submissions and all of that. So I think maybe lawyers don't tell their story well, but the legal vacation is very important for lawyers.
Yeah, because, well, I've heard people saying, so why can't we have a doctor's vacation and all hospitals are closed and we have teachers, whatever it is. I think you're bringing a new understanding to the whole thing. Even the vacation doesn't mean you're off
At all.
You have to be working.
This morning, I sent my managing partner some work that I had to do and sent to her. I sent an affidavit to a client to look at this morning. I can show it to you on my phone. And I'm saying it's a Sunday morning. At least after first mass, I should be thinking about what the preacher said and what the gospel said. But I did that this morning. I can show it to you on my phone now. So it doesn't mean we just go home and sleep. There's still a lot of work to be done. The only thing that is taken away from, that you get respite from, is daily court attendance. You don't have to do that, but we all still go to court once a while during the vacation. It happens.
So thanks for the explanation. So here we are. There's a pending case, and the attorneys are actually resisting that. This is our vacation, and so there's this now tiff between the lawyers and the Chief Justice or the Ghana Bar Association, saying that it is not right to assign any judge to any pending case because this is our time for vacation.
It's clarity we all need on this matter. I explained one point. When they say we are on legal vacation, it doesn't mean no work is done. So traditionally, every year during the legal vacation, the Chief Justice, as the head or the administrative head of the judiciary, appoints judges to sit during the vacation. They sit during the vacation, and by tradition, they are understood to be dealing generally with specific types of cases, like general applications, matters which are urgent. If somebody has been detained, you need a writ of habeas corpus, and all, it doesn't have to abide. You need abide the legal vacation. Somebody wants an injunction. He's not going to wait until lawyers come back from their vacation, however tired they are. He's not going to wait. So you have those matters which can be dealt with by judges sitting during the vacation all over the country. So the Chief Justice has that power as the administrative head of the institution to appoint judges to sit. It also happens that during that period, there could be an understanding that, okay, cases, some trials can be conducted. Trials are more heavy lifting matters that are supposed to wait until the legal year resumes. So generally it's understood that trials are not to be conducted. But if the Chief Justice says, well, a particular judge should sit, and the judge says, there is a part head matter before me and I want you to appear, the Chief Justice does not direct how the judge should deal with those cases before him. You should appear before the judge and make your case to the judge. Now, look, I have been appearing before you throughout this period. I think I need some time off to be able to refresh and come back. The judge has power to adjourn it, and the Chief Justice can't control it. And I'm saying that it is not even the first time that lawyers have appeared in what are supposed to be politically sensitive matters during the vacation. When this argument was going on, I saw people post proceedings involving me in certain matters in which the judge recorded, or what they put forward wasn't certified. We have certified 2 copies of it. But even if you look at what they put out, at the end of the proceedings, the judge said there was consent on the part of the parties for her to go for a warrant. So the suggestion was that, yes, we had all agreed that she should go for a warrant and sit during the vacation to continue with the trial. But you read the entire proceedings and you can ask yourself, even as a layman, that so at what point in time did this agreement take place? Then there are subsequent proceedings in which the judge doesn't refer to what is supposed to be an agreement based on which she's sitting during the vacation. And I went to court during that vacation. But on the 2nd of August, that is 2 days or so into the vacation, she gave me the whole vacation off. Because there was some understanding, even though not recorded, because you have to arrive at some agreement. So my point is that the Chief Justice can exercise his administrative power. The judicial power as to how to conduct the proceedings is with the judge. So initially, my view is not that as soon as a directive is made, as soon as a decision is taken, we start by reacting negatively towards it. Why don't we engage the system in the appropriate way? And when you are not able to reach a conclusion, our democracy allows us options to deal with those decisions. If I go to the courtroom and I try to make a case to the judge that, look, you can't be fair if you insist that I should continue to do this case during the vacation in this particular manner, and the judge refuses, I have options. I know what to do. If you are not happy with the Chief Justice's decision, you can actually go and meet up with the Chief Justice, say, look, as parties, we want to come and discuss this your directive. Does it mean we should continue trials? Or you mean if we have applications in the matter, we can go back to the judge? Let's get clarity on it before we all start saying there's a political motive, there's some interest in the matter, we want a particular result. Whether that is it or not, it appears premature to me. We will get to know that if you start engaging the process legitimately and you don't get the solutions that you want. Or you see, people begin to think that, no, some of these decisions are getting outrageous. I have been on my feet before until court officials had to come and tell the judge that, please, we want to close. I was on my feet for that long. And I knew, and this, there are people who can testify to that. Lawyer Judicial, Randolph Chumesi, they were in the courtroom, and you could see that the judge wanted me to say, oh, I'm tired. So I said, okay, well, then you have finished your case. But I also knew. So you are experienced enough to be able to conduct the proceedings in such a way that people will begin to see that it is unfair how the judge is conducting himself or how an administrative official is conducting themselves. But if as soon as a decision is taken, you don't engage the decision in any way, and you are hearing news about how people are biased and press conferences are being organized, and that's not how to resolve it. And that's not a legal way of resolving issues. Decisions, of course, will always be taken. We all would never be happy with the decisions. But
there's a procedure,
yes, there's
a way
process.
to...
Yeah.
I see. So why would people knowingly just simply stay away from the prescribed way to go? Or they don't know?
It's not that we all know. And the law says that we are all presumed to know the law. And that's why people expected you to sit here and be able to speak the law. We are all presumed to know the law, but we are all different. And so there are certain cases people call political cases or cases of public interest, national interest, and all of that. You can tag them as you like. And you can emotionally connect with them as you like. You can emotionally react to them as you like. Is that the proper way to deal with it? You should ask yourself. That if you go on radio to speak about it, do you get a solution or you inflame passions?
Maybe the idea is to just inflame passions to get people to think the way they want them to think. So you incite passions, and then what does the law do about that?
And the directive is still waiting for you. Are you coming to court or not? Because, as I heard, the judge says, if you don't come to court, the case will continue. But you can go to court and tell the judge that, no, we can't do this because I have A, B, C, D constraints. So the judge is not a person of outrageous conscience. The judge should take that into account. I have done a case in which a client was sick and the judge issued a bench warrant for his arrest because he didn't show up in court. We said the man is sick. The judge still issued that order, and they took the order to the hospital, and the man was lying there. And I said, arrest the man, take him to court.
Wow.
And so you can always deal with these things with the facts. If you are transparent, you can confront it.
So the decision to just totally boycott it is what, premature, or
They can't. I'm not. Sometimes, I mean, with all due respect to my colleagues, some of whom are senior to me, they are my good friends. You can't say you are boycotting courts. In fact, it is unethical to say you are boycotting court. You are you are an officer of that court. So even though you have a duty to serve your client, your primary duty is to the court, because we all are assisting the court to serve justice. And so when you say you are boycotting, this is not a TUC type of situation, or sorry, excuse TUC people to spare me. I mean, or should I understand that, for want of a better word, I had to resort to that. But an officer of the court, you owe the court a responsibility to appear before that court
and make your case.
And the court has powers of discipline over lawyers. That a court can say appear, and you say defiantly that I won't appear. You owe that court a duty to go to the court and explain to the court that, yes, this is my constraint. When we as officers of the court say we are not coming, what impression then are we giving to those who are not supposed to be learned in the law? That a court can say this and I'll say I won't do it.
It's amazing you said that, because that was going to be my next question, or I had planned in the line of questioning to ask you. So what is this, what signal is this sending to people like us? If a lawyer for any reason can say, well, this is my vacation, I won't be there.
You have actually said that
Big lawyers and give defense to my seniors and everything. I say, first of all, that if you look at the Legal Profession Act, the act that regulates the profession, it says clearly that you are an officer of the courts. You owe a primary responsibility in everything that you do to show respect and honor to the court. So you should be the first to appear before the court to say, look, I have this constraint during the vacation. I am not able to do this case during the vacation. And the judge must listen to you and must make a reasoned evaluation of your position, and then decide whether or not to grant you that dispensation. If the judge says, I won't grant it to you, you have options.
What are the options?
You can appeal. After all, the judge is going to write the ruling. You can challenge it. If you think the judge has acted in a way that you are not happy about, you can file some proceedings. You can challenge them in different ways. I don't want to sit down here and give people ideas, because we have all on many occasions had to confront these situations. They are not new. It is not the first time these things have happened. And I've said I've appeared before a judge during vacation, or not a judge, judges during vacation. There are instances in which you can say, oh, the ruling is not right. We have gone to court before expecting particular decisions, but we didn't go on radio to challenge the decisions.
Yeah.
We challenged them in the courtroom and allowed those who wanted to talk on radio to talk on radio. Some spoke about cases that we did that they didn't even understand what it was about. And so let's stop sensationalism. Professionals should remain professionals. Let those who say politics, what they call politics, and I don't think I agree with that notion of politics, that it means go out there, lie to the public, try and influence people negatively, and you call it politics. I don't agree. But
What do you call it?
I think that politics is service to people, and that's what you start telling us, that you want to serve us. So if you want to serve us, and you want to serve us positively, you must come at us with some level of candor and respect for our intelligence and everything. So you should speak to us believing genuinely in what you are saying. But when somebody who calls themselves a politician stands out there and then says, oh, these are the facts, and you know A, B, C, D, and 5 minutes thereafter, the real facts are coming out, and these are supposed to be responsible politicians. 5 minutes thereafter, facts are coming out that just make it clear that you had no reason whatsoever to be putting out or trying to influence people in the manner in which you did. I think there should be some code that sanctions such a person, whoever you are. That an honest mistake is an honest mistake. But when it's plainly fraudulent, you are really defrauding the public that, you know, this is what happened. And then the facts are put before you and it is not true. That's irresponsible. You don't deserve to serve the public. And when you ask them, say, oh, that is politics. That is politics? I don't understand that.
Let me push it further a bit. I'm going to put it in the context of what we are all going through now.
Okay.
We have seen the issue of oral. We've seen some amount of prosecutions, not persecutions. We have seen it based on evidence that certain people have looted, as the name goes. Now, we are in that era now where people are hungry that we have been looted and people must pay for the loot. Considering the atmosphere now, the anger of the people, the eagerness of the people to see that actions are taken, can that be misconstrued as, well, this is the reason why things are done, is because of people's anger on let's say, arrest on oral and everything, and this is what people will put out there to have us believe that all this is to go to political. How do you answer?
So all of that, my candid views, that it's all part of the politics, because we put out information and say, this is what we found out, this is what we found out, and this is what we found out. But we don't add a caveat that these are our perceptions or these are what we think. Even when the Auditor General says, I have audited somebody and these are my findings, we must add a caveat that the person has rights. And that means that the person can challenge and get people to understand that the auditor was wrong. And so, as for people's anger about corruption, we all are always angry about corruption because it affects us. But at the end of the day, we must always remember something, that just how we are incensed to believe that, oh, somebody is corrupt and that some figure has been put out there, that somebody has put that money under his bed and is spending it with his family and friends. We must also remember that an interrogation of those facts can yield a conclusion far different or completely different from what was initially put out there. And I'm saying I have defended a number of those matters. And you can always see that the public is misinformed, especially in relation to some of the banks that were liquidated on grounds that they were insolvent and all of those things. One of the cases that I did, the charges were 40 something, and I filed a submission of no case because you say about 10,000 customers were defrauded by the CEO of the bank. The prosecution manages to close its case without calling one customer. 10,000 customers, you don't call one.
Not one.
To say the CEO has defrauded the bank. In the course of the proceedings, the witnesses are asked, this CEO, did he break the vault to take the money? No. Did he follow procedure as to how the monies were disbursed? Yes. Did one CD go to the man's pocket, either in his bank account, or he benefited from it one way or the other? No. But the judge doesn't see that, no. There is a problem even with proceeding in that manner. You know, at the end of the day, the person has been acquitted by the Court of Appeal. But the public believed that all of those whose banks were liquidated were thieves. And they stole money. And they literally took customers' monies and put in their pockets. So if we are now beginning to see that the courts are looking critically at these cases again, and are saying that no, there is a problem, it will seem to offend the conscience of the person who was initially made to believe that these were thieves. And I'm saying, Sedinam was given 70 some. In fact, the prosecution initially made a mistake. There were 78 charges. They said there were 80. It was a trial judge who found that, oh, they didn't even count their own charges well.
It was 78?
Yes.
And they said
it was 80. It was a trial judge who said no. I've even found out that they are not 80, they are 78. Your own charges, you couldn't count them. So you should see right from the beginning how when you speak out there about a case and when you get into a courtroom and we're now picking the pieces one after the other, so we get to the truth. People say, oh, it is delaying. You want to put somebody in jail and you are saying he has no right to say, okay, you say I have stolen 1 million. We have to go through 1, 2, 3 to find out how we got to the 1 million.
Yeah.
So they are now picking out some charge by charge, and they are realizing that no, we cannot speculate on people's rights. We have to do evidence. And I'm saying in this country, we take people's and we allow certain people to believe that there is no rule of law. Excuse me again, let me use this example. We have our finance minister who is taking advantage, and the supposed most advanced country in the rule of law and in democracy and who teaches us how we should respect people's rights is allowing him every opportunity to take a point that he wants to take for his benefit. Why is it that when it was in our country, Abu Trika and Co didn't get that right to be able to take point by point to the Supreme Court and have their rights declared before they were repatriated? But it reflects how we kind of are mob in the kind of in the way we approach certain things. Oh, he was displaying money about, and so we judge him by that. But how do we deal with him according to our own law? So people people would be sensitive about situations because that is how we put it out there. So as for oral will take time.
Yeah.
So let's understand that at the time oral was put out there to all of us,
the 36 cases that we have reviewed in detail, if we are successful in recoveries, we can retrieve as much as 20.49 billion United States dollars. 20.49 billion United States dollars. 36 cases, and that's from National Cathedral, PDS, MS, SML. You have the GMPC salt pond decommissioning. Then we've also done an estimate of the state capture, the lands. If we successfully ask people to pay conservative market value for the lands they have looted, again, the experts are telling us that we can recover about 702.8 million United States dollars for the Ghanaian people.
It was based on particular information. That is one step of it. The next step is, if you launch an attack against somebody, a judicial one against somebody, it's not going to be like the one that was said on radio, that it is oral. We are going to pick the pieces one after the other until we get to
evidence-based.
Yes, we must do that. And instead of doing it on radio, let's get to the courtroom and do it. Because that's where we are. So that's how I see it. So allow the people who want to do propaganda to do it. But as for a professional, a journalist, reported right. A lawyer, you have no business talking about it if you are. As for those who are not in the case, they can talk what they like because they are not even in the case. When I get into the courtroom crafting the case, you are allowed to sit there and watch, and you don't even know what I intend to achieve with what I'm doing. So you can go out there and make your commentary, but you are not in the saddle. So allow them to do it. But we, those conducting the cases, we should just focus on what we're doing. That's all.
So when you have a case like this where I hear the Ghana Bar Association, the whole Bar Association itself has put something out regarding their reaction to this whole vacation thing, what is your reaction to it? Because this is the Bar Association, and as we know, these are the...
Honestly speaking, I think on this your platform, I've spoken about the Ghana Bar Association. My reaction to it, I don't want to describe it here. You represent lawyers, and I'm saying it is not your first time. I was a victim of holiday trials. You can say I did not protest, but I belong to that association. If you are alive to your responsibility the way you are in certain matters, you should know that there are some lawyers who are working during the vacation, and you keep quiet. And I don't think that as lawyers, the best way was to have written a letter and said, oh, we are siding one way or the other.
Yeah.
Can you even go and you have what it takes as an association representing us as lawyers to walk to the Chief Justice to say, we have seen this your circular, we want to come and engage you on it. And this is what was the circular about, what is it intended to achieve, could we do it this way? The Chief Justice would benefit enormously. He will be very enriched by some of the suggestions you will make to him that will help the judicial system, the public, and the lawyers that you are representing. What is for me, reacting to it in that way didn't make any sense. And I've said before that as a member, I don't think they represent me. Because in every situation that I was in trouble, I never saw them. And if they continue to behave
so
like
who
that,
do they represent?
I mean, they represent some people. I have never felt represented by them. Because I said in many instances in which I was in trouble as their member, I didn't even get a solidarity call. No, even when I met them casually, did any of them say, oh, we've seen what you are going through, but don't you think we should do it one way or nothing like that? But I'd rather see you on the other side fighting against.
So lawyer Thaddeus Sory and I yet saying kase odisa and some tudwa de amaya ebusua enye asem keto akwentino right now no wa expose a disgrace asanso esculi attaching with legal wisdom. Ya better say some JP Nikokoti and some edemai.